This is cause number 140780, entitled LETICA Land versus ANACONDA-DEER Lodge County. Are counsel ready to proceed?
Appellant's ready, Your Honor.
I can see that.
Appellant's ready, Your Honor.
Mr. King.
Yes, Your Honor. Just briefly, I provided a handout to the court. I learned from Jim Gatz, and don't say I don't learn anything. And also, Your Honor, for the record, we decided to divide our time. I will take 20 minutes. Mr. Sturmans, who represents the other appellant and plaintiff, Don McGee, will take 10 minutes, and then I will reserve 10 minutes for rebuttal. My name is Martin King. May it please the court. I represent the plaintiff and appellant in this case, LETICA Land Company, LLC. With me, and also representing the appellate LETICA, is my associate, Jesse Kadadik, at counsel's table. I believe that you know Mr. Sturmans, who represents Don McGee, and I would like to introduce my clients. Billy LETICA, the president of LETICA Land Company, LLC, and his daughter, Mara LETICA, also a member of the LETICA family, LLC. As the court is no doubt aware, this case concerns the status of two roads, and I use the word roads loosely because the Lower Branch Road before 2012 was an overgrown, unused, gated, signed, the culvert was removed, old road that hadn't been used for 30 years. The Upper Branch was not a road. Before 2012, it was basically an unimproved, frankly, scary trail on a mountain ridge that ran from section 23 of the Launderville parcel northwest into LETICA parcel section 22, and then on into sections 15 and 16 in range 11, which is in Powell County, and then on into Forest Service property. The Lower Branch Road, the court declared to be a county road, which begins in section 19 at the intersection of Spring Gulch Road, and then continues through the remainder of section 19, then into range 11 to section 24, then to section 23. And the district court determined that it ended on the east side of section 22, whereas of course we maintain that if there is a county road, which we claim does not exist, at best it ends on the east side of section 23, which is an important consideration as we start discussing this case. Before I get into the meat of my argument, let me make a couple of prefatory comments. First of all, this is not a public access case. The county in their briefs repeatedly try to characterize this case as one about public access to public lands. That's simply not the case here. The public lands that we're talking about, which are the Beaverhead Deer Lodge National Forest, Paziga Lakes, Thornton Lakes, Hunter Lakes, Porcupine Lakes, various trails in the Flint Creek Mountains, are more easily and more safely accessed via a federal trailhead at Racetrack Creek Campground, which is about a mile northwest of the intersection of Spring Gulch Road and Modesty Creek. That Racetrack Campground is a federally maintained campground. It's accessed by a well-improved county road. There is a bathroom there. There's 13 parking spaces. There's camping. And the trails out of there are actually roads that can be used by not only hikers, motorcycles, four-wheelers, horses, mountain bikers. They can get the public to all the same places that these so-called roads, actually trails, can get the public to. This is not a public access case. For 30 years, the public has been using the Racetrack Creek Campground more safely and easier to access the same public lands. This is not a public access case. This case is really about an unconstitutional taking of private property by the County of Deer Lodge over the property of my clients, the LETICAs, and Mr. Sturmans' clients, Don McGee. That's what this case is really about. This is a takings case, not a public access case. Let me say something else too, and that has to do with the use of the term Modesty Creek Road. Both the district court and the county have characterize this name, Modesty Creek Road, as some sort of proper name. Before 2012, neither one of these so-called roads was ever called Modesty Creek Road. They just weren't. So to somehow legitimize these roads by assigning a name to them is just simply wrong. They've never been called that. Until the attorney hired by the county in 2012 to write their opinion letter characterized these roads as Modesty Creek Road, they had never been phrased as such. So I want the record to be clear. They've never been called Modesty Creek Road. They're not a formal. It's not a formal road. They've never been formally named. And in fact, we introduced test evidence that of a map, a county road map that showed a Modesty Creek Road located actually at where Spring Gulch Road is. That Spring Gulch Road itself is called Modesty Creek Road. So let's not get carried away with the name, because these roads have never been called that. So then let me get into the meat of my argument. And you can see in the outline I provided you, it sort of provides the outline of where my argument is going to go here. And I'm going to start first with the lower branch. And as you know, the district court committed or determined that this lower branch road was a petitioned county road that ended on the east end of section 22. The first error that we've assigned to that determination by the district court is the fact that the district court failed to address the conditional declaration contained in the commissioner's report and failed to address LETICA's argument that the condition was not satisfied as reflected by over 100 years of county maps. None of those county maps show this county road. What we argue before the district court, and it's pretty simple, is that the declaration by the commissioners, which supposedly declared this as a public highway, contained a provision that said, with the provision that all parties interested or benefited by said road bear all expenses with the opening and building of the same. The county's attorney omitted this language in her opinion.
So you acknowledge, I assume, Mr. King, that the county maintained that road for several years?
No, I don't, Your Honor.
There was evidence to that effect.
The only evidence of maintenance of this road, and I'm glad you asked that question. The only maintenance of this road is as follows. First of all, the upper branch road was never maintained. There's zero evidence that the upper branch was ever maintained. With regard to the lower branch, there was no maintenance done after 1965.
So you just contradicted yourself. There was maintenance done.
Okay, well, let me tell you.
From the time it was declared a road in 1889 until 65.
No.
Periodically.
There's no evidence to support that. The only evidence there is to support that is the testimony of John Thompson, who was the road supervisor until 1989, and also from Larry Stern, who is the present road supervisor and has been since 1983. Between 1953 and 1965, the county did some work on the lower branch road on 5 different occasions. Each one of those occasions was at the request of the landowner, Sport Pododnik. And the 5 instances of maintenance were this. There were 3 instances of plowing, and there were 2 instances of blading, all at the request of the landowner, Sport Pododnik. And at each time, the maintenance never went past the east side of section 23. So there's zero evidence of any maintenance past the east side of section 23, meaning west of the east side of section 23. And the only maintenance that there ever was at the request of the landowners. And when the landowners didn't request the maintenance, it stopped. And after 1965, no maintenance. There's zero evidence of maintenance. And there's zero evidence of maintenance ever on the upper branch.
Is maintenance required for a petitioned county road to be established as, would that make the district court's ruling erroneous if there's no maintenance? On the lower branch only?
Would it? No, not necessarily. Clearly the law doesn't require maintenance in order for there to be a petitioned county road. But to the extent that the county has suggested in their briefs that there was maintenance and have sort of implied that maintenance was provided to the upper branch, there's no evidence of any maintenance at all with regard to the upper branch.
We're talking about the lower branch.
Okay, lower branch. So in any event, what we argued and what the district court failed to address in any fashion was that the declaration in the commissioner's report supposedly declaring this as a public highway contained a condition. And that condition mapped the statute that was in existence at the day, which is in the back page of my handout, and that is section 1819 of the general laws of the 1887 statute. And that statute says, provided that if in the opinion of the county commissioner such a road is not of sufficient importance to the public to cause damage to be paid by the county, they shall refuse to establish the same as a public highway unless the expenses and damages or such part as they deem proper shall be paid in advance by the petitioners. Meaning that until they pay the money, there's no county road.
Excuse me, counsel, but
Yeah.
who says there was any money owed?
The
Just
commissioner-
because it says in the statute that this is a provision doesn't necessarily mean that anybody has to be paid.
I think it does.
Well, why? Just because
Because
it
the
says
statute
this is
says
a
it.
provision?
Because the statute says it and the provision in the declaration requires it. The county could have done three things when this road petition came to them. They could have said, no, we're not going to accept this as a petition county road. They could have said, we're going to accept it as a petition county road and we're going to bear the expenses, which they have the option to do under this statute. Or they can say, hey, we'll open as a county road, but you have to pay the expenses. And until you pay those, there's no county road.
Counsel, is it your contention that the county had to prove the payments were made in order for the county road declaration to be appropriate?
Yes.
What about the holding of Powell County versus Five Rock and Angus Ranch, which addressed a road of the same vintage? And the court there said that it would be too onerous a burden to require the plaintiffs to produce a complete record of the proceedings that occurred that far back. How do we reconcile your argument with that holding?
Dealenberg, the Rocky 5 case, didn't address this issue at all, period. What happened in that case, the only relevance that case has to this case is that it's a near geographic location. In the Rocky 5 case, this argument that we're making today was not made. The argument there were two different things, really. They argued first that the location of the road was not well described and therefore a county road could not be created. We're not making that argument, but that's what we made in Rocky 5. That was rejected. And then the other argument that they made was that they couldn't get a county road over state land. That argument was rejected.
But to follow up on Justice Cotter's question, I think the legal standard that we've applied since Reed is that proof of every single item that's necessary for a petitioned road doesn't have to be made in order, if the record as a whole shows that the road is there. So my question is this lack of evidence on the condition precedent qualitatively different from the lack of proof of other elements that we have found doesn't defeat the county road? And if so, what's the qualitative difference?
The qualitative difference is the language of the statute and the language of the declaration itself. Now, I'm not saying you have to find every single piece of document, piece of paper that may have any relevance to this case. I think that's what Reed holds. But I do think that the county has an obligation to meet some limited burden to prove that they've complied with the law. That doesn't mean under Reed we have to provide every single piece of paper. But it does require that the county itself has to meet its burden to prove that it complied with the provisions of the law. And here...
But counsel, the county could have created the road without requiring any payment,
right,
correct? So, I mean, but so by the same token, couldn't they put that in the commission minutes and then just waived the payment?
Under the statute they could have, but they didn't.
Well, we don't know. I mean, the absence of, I'm just, I guess, kind of picking up on Justice Baker's question. I mean, what is qualitatively different from not receiving a payment and waiving a payment?
Because the statute specifically provides a distinction, as does the resolution that the commissioners passed.
Right, but the statute provides and would allow the commission to decline the payment or just not seek a payment.
I don't think the statute allows that. I think the statute says we can declare this to be a county road and impose whatever condition we want. And what they did here was said, we're not going to declare it a county road. It's not going to be a public highway until you pay. And I think at a minimum, the county needs to present some kind of evidence that happened. Look at their response. They say,
What about the curative statute that was passed in
I don't
1895?
think it cures their obligation to prove compliance with the law.
Counsel,
Well, so you're saying the county has the burden of proving that this is,
That's correct. I don't
so
think
it's
I-
declared a pub, go ahead.
I'm sorry.
No,
I
you
don't
go.
think that I, as a landowner, have the burden to disprove the existence of a county road. I think when they come in and say, we have a county road under this 100-plus-year-old record that has basically 3 different documents, that's all there are, they should have to prove or at least present some kind of evidence that the condition required by the law was met. And they didn't even address it, Your Honor. In fact, their argument in response to our argument is we didn't carry the burden. It's not our obligation to carry the burden. In fact, the case they cite in their brief, Oates versus Knutson, the late Warren Oates, says that the county has to carry their burden to prove the existence of the county road. This is their own case. My problem is the district court didn't address it. Whether we met the burden or the county met the burden or any of that, the district court refused to address it at all, ignored it entirely. Didn't address it.
Counsel, let's take a trip back in time here, because in the district court's finding of fact number 31, it addresses this commission meeting on June 3rd, 1889, and you're probably much more familiar with this than I, but let me read the part to you because I think it's important. I'm not going to read the whole thing, but it says that they met and, quote, accepted the same, is hereby accepted, declared, and they're talking about this road we're talking about, is hereby accepted, declared a public highway. So they declared it a public highway with the provision that all parties interested or benefited by said road bear all expense connected with the opening and building of the same. And I'm back to my original question. There may not have been any expense. There might have even been some agreements between the parties that were using. You don't know that because you weren't alive in 1889 and you haven't brought any evidence forward to say there wasn't. I'm just saying there could have been, and I think that's where the district court has addressed this.
The district court didn't address it, Your Honor. Nowhere in the district court's 74-page order does he address this statute or the conditional declaration.
Right. What you're saying is the district court didn't address this payment that should have been made. Because the court didn't, then the statute hasn't been complied with.
They didn't address our argument, period. They didn't address our argument. They didn't address the condition. They didn't address the statute. He ignored it entirely. The county's attorney omitted this language in her opinion when
Mr. King,
they made the decision to open the road.
I think we understand your argument on the lower branch, and before you run out of your 20 minutes, I want to ask you a question about the upper branch road. One of your arguments is that even if there was sufficient evidence to show a prescriptive easement, that it's been extinguished.
Correct.
And we said in the Boone and Crockett case that for a public prescriptive easement to be extinguished, the assertion of the right hostile to the public owner must be brought to the owner's attention, and the use must continue for the full prescriptive period. So I wonder if you could briefly summarize the evidence that was presented in this case that would support that position that you're arguing.
Sure. The roads were gated in 3 different places. The lower branch was gated at the intersection, at the fork in the road on the Launderville property. It was gated at the boundary between the McGee and LETICA property.
And so,
in Section 24.
We're
And
talking
most
about-
importantly, it was gated at the intersection of Spring Gulch Road.
and which of those gates goes to the upper branch? All of them? Or
Well-
not the orange gate, right? That just goes
Well,
to
the orange gate, there's one lower branch road. It goes to Section 22. And in Section 23 on a non-party's property, Launderville, it branches off to the northwest. Launderville had a gate on his property that's not on the county road. There was another gate that was on the so-called lower branch that was at the intersection of the LETICA and McGee property. That's the green gate. and then there was another gate that was right at the culvert, right at Modesty Creek, that was placed there in 1981.
So the extinguishment argument applies only to a prescriptive road, so we're only talking about the upper branch when we're talking about extinguishment,
That's
correct?
correct.
So that's what I'm interested in. What evidence would show the notice to the owner of the assertion of the hostile?
3 gates.
Right.
Right,
First of
on
all,
the
let
public, right near the public road. The culvert that was there at Modesty Creek was removed in the early 1980s. So if any owner of this easement, the public, came to the intersection of Modesty Creek, where the road goes up Modesty Creek, they would see there's a gate, and they would see there's no culvert there to cross that had been there for no culvert had been there for 18 years. They would see no trespassing signs. There were ads placed in the newspaper telling the public you can't use this road anymore, back in the 1980s, and there was a berm constructed on the upper branch into the Forest Service. So there was a whole lot of action taken. Moreover, nobody went up there for 30 years. And as we point out in our brief, under 70-17-111, any easement obtained by prescription can be lost either by some act taken inconsistent with the easement or by just mere non-use. That's what the statute says. And the evidence here was there was no use after 1981. It was basically none. And they went the racetrack creek way.
Mr. King, just I want to jump ahead just because when we're talking about the upper branch and the prescriptive easement, you had said in your brief and in your handout here, error number 6, that the district court applied the wrong standard of proof to the prescriptive easement claim.
Right.
In conclusion of law 65 at page 67 of the district court's order, it did say substantial evidence, but it said substantial evidence in the record is clear and convincing. Isn't that the correct standard, clear and convincing evidence? I mean, you seem to imply that the district court...
I don't think it is, Your Honor, and he uses substantial evidence in other parts of his, on other parts of his opinion and order, saying that there's substantial evidence to support a prescriptive easement. The county themselves use that phrase in their brief.
But
I don't think that's
the dispositive conclusion there at 65 was that it was clear and convincing that, and then he proceeds to go on to the elements of prescriptive easement.
He used both substantial evidence and clear and convincing in the same sentence. He did. What that means, your guess is good as mine. One thing I want to mention, and that is that the court nowhere in its 74-page order did it reference in any way what we believe to be the most compelling evidence of the case, the 1913 Deer Lodge County Road Map. And the reason is because that's the first county road map created after this so-called declaration. And that county road map, which is in our brief and is in evidence, does not show a county road. In fact, 100 years of county road maps show no county road along Modesty Creek. Nowhere in the court's opinion and order does it even mention that 1913 county road map. The court didn't consider the record as a whole. Didn't consider it. Nowhere is it referenced. The most compelling evidence of the entire case. Now I'm going to sit down now because I've run out of time and I want to reserve a little time for my rebuttal and for Mr. Sturman's. We ask that you reverse the district court. Thanks.
Mr. Chief Justice, may it please the court, I would like to quickly acknowledge the work of my associate Jeff Kuchel, who's seated behind me here today, and my client Don McGee from Butte America, who is here as obviously a very interested observer. I would like to go right to one of the questions about the Bielenberg Road case, and I think it's important to note, as we did in our briefs, that there was no dispute in that case about whether there was a county road. That was in the opinion. So they were using the evidence for a totally different purpose than what was used in this case. And I think if I could condense our gripe about this to one sentence, and I think it poses a problem in terms of its precedent. I think it'd be a horrible precedent. I don't know where it would leave people who are buying property, landowners, title companies, if this case is upheld. But it's that there's an indiscriminate use of evidence that goes to prescriptive claim with statutory creation of a public road. And the questions here have really are born of that confusion or the blend, because there's no clear line from the beginning. Never was a clear line. When we, in March of 2012, when we moved to enjoin the county, the featured piece of evidence that the district court really liked was a Google map that county's lawyers blew up and put on the wall. They taped it together, and it's in evidence. And, you know, as a demonstrative exhibit, fine. You know, as evidence, if you know you've got a county road and you're trying to fix the location, maybe okay. But as the thing that really persuaded Judge Kruger, we were off the rails at that point, and we have been ever since. You know, a fundamental aspect of this, I think, is that we're talking about, of course, these particular landowners. But when you speak of the record taken as a whole, we firmly have been convinced all along that that's not the record that the court creates in a trial. And that's the way the judge's findings are treated. He finds that the record that was made when we litigated this case is the record for him to consider. All of the cases in which this court has discussed the record taken as a whole have focused on what you would think ought to be the inquiry, and that's the county's records. What do their road documents show? What do their petitions, their commissioner's minutes and so forth show? And we ventured instantly way beyond that, to the point where I don't know how, if this opinion stands, any title company could, you know, and they accept easements out of their title opinions. There's case law in Montana about the reasonableness of title companies excluding coverage for prescriptive easements. I get that. But there's also case law that discusses, you know, what the title companies ought to be looking at, and that's public records. After this case, I don't know what you'd say is a public record and what you say isn't. The district court certainly didn't make that distinction.
Mr. Sturmitz, I think that's an interesting argument. I guess what I'm wondering, in the other cases that we've considered, we have looked at other evidence to support the court's finding of the record as a whole. We've looked at witness testimony. We've looked at other maps, USGS maps or Forest Service maps. I'm not sure where we draw the line between what's appropriate to consider as part of the whole record in looking at historical documents and uses.
My response to that, Justice Baker, is that I don't think the court has ever been faced with a situation where it really had to draw that line.
So if we're talking about the lower branch, and the title company is trying to figure out whether there's a road, it seems to me we've got a public record that declares it as a road. So the title company's not going to have any problem with that. So I assume your comments are addressed to issues regarding prescriptive easements, which are always heavily fact-based.
They're also addressed to the lower branch because
well, the title company's going to look at that record, right?
They'll find those documents, yeah. But included within those documents is this express provision. And the problem we have with that is, how do you endorse a standard which allows the district court to on the face of the documents? I mean, this is not judging witness credibility. This court is in as good a position as Judge Kruger was. County documents that have this provision in there and don't even mention it.
Counsel, I've got to direct this inquiry a little bit here. It seems, I mean, our precedent has been all over the board, in my opinion, and I highlighted it in my dissent in PLAA, where we've confused public highway, county road, state highway, public
in the context of easements as well. I think that Title VII, in terms of the creation of a county road, is clear as to how a county road is created, at least currently. My question pertains to the 1887 statute. Is there any, implicit in all of these statutes is a requirement that no county road be declared absent approval by the commissioners, which once they approve, they're obligated to maintain those roads. And we don't shoulder that burden on the county government, county commissioners, until that process has taken place. Is there anything in our case law that says, and I have to say the 1887 statute is not as artfully drafted as Title VII in terms of the creation of a county road. Is there anything that follows in terms of our authority that says a county road can be declared where the commissioners have not followed through with a resolution specifically adopting that county road? And is that required in the 1887 in this case? We don't have a resolution, do we?
No, we don't have evidence of that, and I do not recall a case that stands for the proposition you mentioned.
Maintenance? Does maintenance come into play?
Well, I think all I would say is that the language that was reflected in the commissioner's minutes comes straight from the statute. We do know that. This was not just manufactured by them. It was not, just a condition that they thought might be a good idea. And that's the problem we have here, and why I can't concede that the documentation is sufficient to say that there was a statutorily created county road on that lower branch, because we're not considering part of the statute. And the standard, however inartfully the laws were written back then, is that, you can tell from the records that the statute was complied with on the partial records. And I don't see how we get there. Except by putting the burden, which is what happened here, on us to disprove that this occurred.
Counsel, when you talk about the record that the district court based its findings on, we're talking about the court record. The district court didn't base its finding on anything that wasn't presented during the trial, did it?
No.
Okay. Were there any objections?
To the
exhibits that all went in, my recollection from the findings of fact and conclusions of law, that the exhibits were admitted in trial were all presented by stipulation, were admitted by stipulation.
Stipulate, I think, some of them as to authenticity, with some major exceptions. We had a motion in limine that the court never ruled on. For example, to exclude those reports from the School of Mines, the tech, that the judge featured so largely in his findings. We objected to those mightily. So I think there's a consistent record from starting with our injunction hearing all the way through to objecting to the use of, to considering the miscellaneous use evidence, the hearsay, all that sort of prescriptive easement kind of thing to the lower branch. And we had problems with the upper branch too, because that wasn't, recall that this case didn't start out having anything to do with prescriptive easements. This bears no resemblance, what we're arguing about today, to how this was pleaded by the county initially. The road that they relied on, or the documents they relied on to say there was a statutory road up to public land, evaporated. And at that point, the county shifted gears and decided they wanted to pursue a prescriptive claim. We had stipulated that there was no claim initially for a prescriptive easement.
Mr. Dermott, you're eating into your rebuttal time.
Oh, I will stop then. Thank you. Appreciate that.
Ms. Walker.
Good morning. May it please the court. My name is Cindy Walker, and myself and my colleague, Mark Thiessen, it's a privilege for us to appear today before you on behalf of Defendant Appellee ANACONDA-DEER Lodge County.
Counsel?
Yes.
I want to get right to something here, okay?
Perfect.
You heard this part of finding of fact number 31. which I read, where the commissioners, they accepted and declared a public highway. And you heard the response from council. What's your response to how to treat that statement by the county commissioners back in 1889?
The county's response, Your Honor, is that that road was declared a public highway on June 3rd, 1889. It is unequivocal that the declaration occurred, and what they stated, similar to the case of 5 Rock and MS, that the expenses associated with building and opening the road would be borne by the petitioners in that particular case. There's no requirement that the county prove that those expenses were paid by those folks. Keep in mind as well that the road that was petitioned for in 1889 was an existing road. There was mining activity that was occurring up in Dry Gulch as early as the 1860s, and what the petitioners were after was, as stated in the actual petition itself, to have an existing road declared as a public highway. It's not necessary, as the court has stated in Reed and its progeny, that we must produce every piece of evidence to support that the statutory requirements for creation of a county road occurred at that particular time. In any event, there's no evidence that the commission in this case imposed that statute that's been referred to by the appellants in this case by saying, if in their opinion they didn't feel that that road was of enough importance to declare it and bear the expense, they didn't refuse to declare that as a county road until those expenses were paid. They did declare it on June 3rd, 1889.
Counsel, is there a distinction in your mind between a public highway and a county road?
No, there isn't. Based upon the statutory language that occurred at that particular time, especially given the fact that at the time of the petition, Deer Lodge County didn't exist. The state of Montana didn't exist. It didn't come into existence until November of 1889. So in my opinion, what was occurring at that particular time is what is happening at the commission level is a county road is being declared. Public highway, county road are synonymous.
Is there a distinction currently in the law between a public highway and county road?
I believe there are.
To follow up on Justice Weed's question, the other significant piece of evidence the appellants argue was completely disregarded by the court is the 1913 map. Could you address that?
Yes. The 1913 map was considered by the district court. There's an entire section in the findings of fact that addresses the maps that the plaintiffs presented where they claimed didn't show Modesty Creek Road. In fact, that's not true. There are some more recent maps that don't show it, and whatever purpose those maps were created was never established, nor is that in evidence. The 1913 map itself, if you look at it, there is a portion of Modesty Creek Road depicted on that particular map, and then the unsurveyed portion is blank on that map where Modesty Creek Road continues into that particular section. So the district court did consider that piece of evidence and gave it the weight it felt was appropriate. In light of the
only map that
evidence.
designates it as a public road or a county road, though, is the undated map that was found in 2013, though. Isn't that correct?
That's incorrect. The other evidence, there is the actual book of road district maps that had been created in 1896 by H.B. Davis. The county hired H.B. Davis in 1896 to prepare maps of each of the road districts, and that's reflected in their commission minutes as well. So the district court looked at a significant amount of evidence in relation to whether or not the statutory requirements were met for creation of this road at the time. The first of which being the 1889 commission meeting minutes, where it establishes that a petition was filed, notice was given.
No, I understand. I'm talking about post-petition. Is there, and I know that there are maps that the district court went through that reflect the existence of a road, but other than the undated map that was found in 2013, is there a map that shows the road and reflects it being a public road or a county road?
Yes, that's the map of road district number 5. And that was in an entire book of the road district maps, and that were included as evidence in this case.
That's the 1896.
You're correct, 1896. In addition, there are other maps following that. So it's untrue that there is no evidence. There were Deer Lodge County maps that depicted Modesty Creek Road as a county road. There were general highway maps, as well as the government land surveys, et cetera. The district court didn't rely on those other maps to satisfy the statutory requirements for creation of the lower branch as a county road at that particular time. What it said is, I find further support in these additional documents after that period of time for my findings and conclusions that the lower branch was indeed created as a county road on June 3rd, 1889. And keep in mind, the standard of review to be applied in this particular case is whether or not the district court's findings of fact are clearly erroneous and whether or not the district court's legal conclusions are incorrect. Neither of the appellants have established that the findings of fact, which are significant in this particular case that were entered by the district court, in fact 173 findings of fact, based upon hearing over, approximately 28 witnesses and hundreds of pieces of evidence in this case after a 5-day bench trial, as well as conducting a judicial site view at the close of the evidence in this case. So he went the extra mile as well to go out and view the road and the surrounding area in making his findings and conclusions, which are supported by substantial evidence in the record, and the conclusions that were entered are correct. In examining the sufficiency of the evidence, this court must view the same in light of the prevailing party, which is Anaconda-Deer Lodge County in this case.
Ms. Walker, I'd like to ask you a question about the upper branch specifically. The district court made extensive findings on the upper branch, most of which refer to use prior to 1980. Can you summarize briefly what evidence of public use there is in the record of the upper branch after 1980?
Yes. The use includes not only people using the road to access the mountain lakes located in national forest land, as it also includes water rights holders, people employed by the water right holders to manage their water rights on those lakes, as well as the United States Forest Service, the Fish and Game, the Soil Conservation Service. In the evidence itself, there are what are referred to as dam inventory sheets that were prepared by the Forest Service based upon their monitoring of those dams, either on an annual basis or every couple of years. You'll see that stretches through a significant period of time, as well as when some of the water right holders had filed an application to rebuild a dam on one of the lakes there, and that's when a number of the agencies also went in using Modesty Creek Road. And by the way, I wanted to mention that Exhibit 593 is the environmental analysis that was done in connection with the rebuilding of that dam, refers to access to these lakes via Modesty Creek Road, and the road is referred to in those documents as Modesty Creek Road or Modesty Road number 5146. Keeping in mind, Modesty Creek Road, the lower branch, connects with Forest Service Road 5146. This has been the case for over 100 years.
Counsel, addressing also the upper road, in the Dome Mountain case, I think we held that there must, in order for a claimed right in a prescriptive easement to be continuous and uninterrupted, the use must not have been interrupted by the act of a landowner. We have argument here and evidence in the record that the landowners did undertake specific acts to block access to the upper road. And I wonder if you can reconcile your position with the Dome Mountain case in that respect.
I can, Your Honor. With respect to Dome Mountain, the county acknowledges that a landowner can reverse, adverse possess a public prescriptive easement. That didn't occur in this case. The district court found that the plaintiffs failed to prove by clear and convincing evidence that reverse, adverse possession occurred for the prescribed statutory period. If you look at the evidence in the record, the only action taken with respect to the upper branch was by Mr. Launderville for a period of maybe 1 to 2 years at most. And that was when Mr. King was going through the description of the various gates on the particular road. The two gates, the orange gate and the green gate, are located on the lower branch road. And that locking off of those particular gates, there's still no proof of a continuous 5-year period during which that road was locked. And in fact, if you look at the statements by Mr. McGee in his brief, as well as some of his testimony in the record, after he purchased the property in '97, he traveled beyond the green gate on his bike and accessed the road. There's no mention of the gate being locked. When he purchased the property, he says he doesn't recall the orange gate being locked. In addition, Mr. Launderville, who worked for Mr. Letica for a period of from 1994 to about 2004, stated that after the gates were locked, people still continued to use the road during that particular period of time by either cutting the fence or cutting the locks. He was continually having to, talk to folks, but they still used the road during that period of time. In addition, the Becks rebuilt their dam, I believe, through the 1980s, and it still continued. The use continued beyond that period of time. So the district court properly held that the reverse adverse possession was not proven by clear and convincing evidence by the appellants in this case.
Counsel, in follow-up to that question, how do we analyze the fact that the orange gate and the other gate on the lower branch effectively prohibited access on the upper branch? And would there have been a need? I mean, that's the only way you can get to the upper branches is to go through those locked gates.
From our perspective, first of all, the district court found that those were not locked for a continuous 5-year period from that point in time, and that was what was critical here. Is there's been no evidence, the evidence was not clear and convincing, certainly, that those gates were locked for a 5-year continuous period. And that's borne out by looking at the appellant's own representations in their briefs, as well as their testimony concerning access that continued after ownership by these appellants of the property.
Well, wasn't there testimony, and Mr. King alluded to it as well? I mean, there were the existence of the gates from 1980, 1982, respectively, I think the orange and the green gate. And then wasn't there also posting, though, of no trespassing? And I mean, is it required that, you put a gate, lock it, post it? What's required to establish that you're attempting to deny access to a road?
Justice Shea, and I would direct the court to the record in this case. There was no evidence introduced concerning the posting of no trespassing signs on either of these properties, and the public certainly did continue to access Modesty Creek Road during the period of time that there were locks on the gates, and it was merely periodic at best during that time frame. There's even reference to a peaceful demonstration that occurred in January of 2012. If you look at an opinion article, which I believe is Exhibit 34, that was written by Mr. McGee, he talks about after the continual parade of hunters on an annual basis, and that the livestock, or not the livestock, the elk and the deer would then be at rest after that particular period of time, and that the continual, what he refers to as vandalism, meaning the cutting of the fences, et cetera, continued. And that was an article that he wrote in 2012.
I'm sorry.
Counsel, there have been representations made in the brief by LETICA that the county failed to object to the gating of this road for over 30 years. Is there any evidence in the record demonstrating that the county did, in fact, object to the gating of this roadway during that 30-year time frame?
I don't know that there's any evidence by the county necessarily, but there certainly is evidence that the public objected. Attached to Susan Callahan's memorandum is a 1999 Montana Standard article that refers to various members of local sportsmen's groups who were complaining about the gate having been locked or not having access along this particular road for periods of time.
But the county took no action during that time, is that correct?
That's my understanding, yes, because the locks were only on there periodically and not all the time. And so they didn't take any particular action. And if you look at the testimony from Connie Turns-Daniels, who's the current chief executive for Anaconda-DEER Lodge County, she testified that during this particular period of time, the county went through the smelter closure, a lot of folks were unemployed, they had a lot of other priorities at stake at that particular time. With respect to the allegation that the use was permissive after the Anaconda Mining Company took ownership of the property, the Anaconda Company owned the property from 1937 to 1965, after which it conveyed the property to Mount Hagen Livestock Company. There's no evidence in the record, and the witnesses testified that they did not ask for permission from the Anaconda Company or Mount Hagen Livestock Company to use the road. They did it as a matter of right and continue to do that. And as this court pointed out in Linz versus Green, it's well established that a landowner's passive acquiescence to another's use of his land is not evidence of permissive use. Permission means more than mere acquiescence. It denotes the grant of permission, in fact, or of a license, which there is no evidence that the Anaconda Company or Mount Hagen Livestock Company granted permission to the public to use Modesty Creek Road. In conclusion, I'd like to address some of the comments that Mr. King made at the outset of his argument, which are, this is not a case in which one morning each of these landowners woke up and discovered that a public road had been blazed through their property without any notice. This road has been in existence since the 1860s. They were certainly aware of it as in the existence of this particular road, the use of the road. In fact, Mr. McGee mentioned that it was always a battle finding that the fence had been cut and having to deal with evidence of adverse hostile use of the road to his particular ownership interest in the property. In any event, Mr. McGee's property, only the lower branch crosses Mr. McGee's property, which is a petition for a county road.
Counsel, what is the status of the remaining claims, and are there still remaining claims that need to be resolved?
It is my understanding, Your Honor, that those claims were bifurcated by stipulation of the parties, which was entered in 2013, not 2012, as represented in the appellant's briefing. There was no rescission of that stipulation to bifurcate those claims after the second amended complaint was filed. And the county, in its opening statement, referenced that specifically by stating that the only claims at issue were whether or not public rights-of-way existed over the plaintiff's property. There was no objection to that, and the district court very specifically in its findings and conclusions stated that those claims had been bifurcated. It's my understanding that after this appeal, those claims would then be addressed depending on the outcome of this case.
I'm sorry, go ahead. Okay. Counsel, what about in terms of the lower branch, assuming the lower branch of Modesty Creek Road exists, that the argument that the map appears to depict it terminating anywhere from half a mile to a mile short of where the district court ultimately found that it terminated because there was a conflict as to which was, I guess, Schick Gulch versus Dry Gulch.
With respect to the location of Dry Gulch, Your Honor, those maps are very clear, and the minutes, the commission meeting minutes themselves state that the end of the road is as near as practical to the mouth of Dry Gulch. There's never any question about that. What was in dispute, the plaintiffs were claiming that the location of Dry Gulch was somewhere other than it is. And the district court very clearly found that their expert was unpersuasive in his arguments by stating that the location of Dry Gulch as depicted on the 1896 map, as well as the other maps in the case, went into an unsurveyed section. In fact, the grid lines don't even continue over onto that section of the map, so it was improper to then extrapolate by an inch, which the other portion of the map was to scale, but that particular section was unsurveyed at that time. And H.B. Davis, who was hired by the county to prepare maps of each of the road districts was only limited to the lands that were surveyed by the government at that particular time. So it's unreasonable to assume that you could continue that same scale onto an unsurveyed section of the map. Dry Gulch and the district court went through copious detail of all of the other evidence establishing the location of Dry Gulch, including the judicial site view where we hiked up Ship Gulch and Dry Gulch. And we're able to observe for ourselves the evidence of mining activity in Dry Gulch, which is located in section 22. The district court entered comprehensive findings of fact and conclusions of law after observing 28 witnesses and hundreds of pieces of evidence over a 5-day trial, conducted a judicial site view, and there's been no showing by the appellants that the findings of fact entered by the district court are clearly erroneous or that the district court's legal conclusions are incorrect. And Anaconda-DEER Lodge County respectfully requests that the district court be affirmed. Thank you.
Counsel, I have one question left.
Yes.
When I look at the commissioner's minutes, it indicates that the parties interested or benefited, I guess that would be the petitioners, of the road bear all expenses connected with opening and building the road. And the statute specifically requires that unless the commissioners believe that the damages are worthy of being paid by the commissioners, the road should not be declared a public highway. Now, there is the unless provision that payment be made in advance by petitioners. What significance, if any, are we to, or can you address that inconsistency and how the commissioners handled the petition under the 1887 statute?
I don't believe there is an inconsistency. If you look at the commission meeting minutes for the 1889 declaration, it doesn't state the county shall only declare this a public highway if these expenses are paid in advance. It declared the highway open as of that date and said the folks who were interested or benefited by that particular road should bear the expense.
But that wasn't in compliance with the statute.
And there's no evidence that that particular statute was employed by the commission at this time. And if you look at 5 Rock and MS, this court looked at that same language that was used and determined that county roads were created in that particular case.
Right, but okay. So they basically didn't have to follow the statute in creating that public highway.
No, they did follow the statute, which required that a petition be filed, notice be given, 3 road viewers be appointed, and that they report back to the commission, and that their report be approved, and the road was then declared open as a public highway as of that particular date. And so each of those elements for creation of a public highway that required by the statute were satisfied. And that's what the district court determined in looking at the historical documents, meaning the 1889 commission meeting minutes, then followed by the 1896 mapping of the road districts, as well as those commission meeting minutes that discuss that particular issue, and those elements were satisfied. There was no indication that the commission intended for this road not to be declared a public highway until those expenses were paid. And the Reed Doctrine allows for the record to be taken as a whole, given that these documents are well over 100 years old, and it's virtually impossible to find every piece of evidence to establish each element was met. Thank you.
Thank you, counsel.
Thank you, Your Honor. Our argument is this. After the road was conditionally declared to exist, there's 100 years of no evidence of the county ever exercising any kind of control over the lower branch. And there's 100 years of no county road maps showing this road in existence, primarily the 1913 county road map. And that led the court to make this finding of fact number 63. It is unclear why the county stopped mapping the Modesty Creek Road in these recent maps, and no evidence was presented at trial explaining the county's recent failure to map the lower branch of the Modesty Creek Road as a county road. So the court ignored the 1913 Deer Lodge County road map and ignored our argument that it was not created as a county road, as evidenced by the fact that over 100 years, no county road map showed this road in existence. And I would take major exception to the statement by Ms. Walker that the 1913 county road map was considered by the district court, because it simply wasn't, as indicated by finding of fact 63. And I would also take exception to her claim that this road was shown on the 1913 district road map, because it wasn't. It's not on there, period. It's not on any county road maps. The 1913 county road map, the 2005 county road map, the 2012 county road map, or the 2013 county road map, or the fuel tax maps, which map county roads. Our argument is the condition was never satisfied, as indicated by the statute and as indicated by the non-recognition of the county for 100 years. And the court didn't address that argument, just didn't. Second thing, with regard to the location of the lower branch road, there's exactly 2 maps that show this road. There's the Davis map, and then there's the undated map that was found in the Lost Road Book. And that is Exhibit L33. And both of them show the same thing, which is this lower branch road ending in the east side of Section 23. The county and the district court used hearsay evidence from mining documents from Montana Tech that mapped geology and didn't have anything to do with the county road, plus some anecdotal evidence to say that Dry Gulch was at the east end of Section 22. And the reason they did that is because they wanted to connect it with the upper branch. There's absolutely no county records to support that, because every single map shows that road ending on the east side of Section 23, without exception. Secondly, with regard to this idea about use after the gates were placed, the district court's conclusion with regard to the reverse prescription claim wasn't based on adverse use after 1980. The court didn't find that. Its entire claim was based on conclusion of law number 77, which says, and I'm quoting, in fact, or since a private individual may not obtain title to a publicly statutorily created road by adverse possession, blocking the statutorily created lower branch road at the Orange Gate and Green Gates did not grant the landowner adverse possession of the lower branch road. In fact, the landowner never had the right to block the lower branch road in the first place. Thus, it would be improper for this court to adopt a policy that allows an individual to illegally block a public statutorily created road, the lower branch road, and claim that the public prescriptive easement over the upper branch road that branches off the lower branch road, nearly a mile down from the Orange Gate, is extinguished by reverse adverse possession. Such a holding would be against public policy. That was the court's holding on the issue. There wasn't evidence of use after the gates were placed in 1980. There wasn't. And the court's conclusion wasn't based on use.
Lauderville's testimony even says it was used.
He didn't. What Launderville said was he saw Sean Demers come through, and that Sean Demers didn't even use this road. He used another route. There were actually 2 people that testified they went past the gates. Demers, who said that he had permission and he didn't even use the road, and a guy named Leo Nichols, who was a water right holder, who also didn't use the road. He went another way. So there was no use after 1980. And the court's decision wasn't based on that.
It seems like the district court, in addition to deciding the issue on the basis of a conclusion of law, that it's not possible by way of public policy for this reverse prescription to happen here. It went on in 78 to find that the Upper Branch Road was never blocked for the statutory period. So it seemed like it also used findings of fact to conclude that as well.
Right, but if you look at the statute, which the court never addresses, 70-17-111, it tells you how easements that are obtained by prescription can be terminated. And one of them is by any act that interferes with the easement or by non-use, both of which were present here. The court didn't even address that statute. Its whole thing was this conclusion of law, which is not supported by any authority whatsoever, and it runs face into the statute. Remember, the district court originally found that this road was terminated by reverse prescription in its order in July of 2012. It then changed its mind after the county found its lost road book, and their whole theory that the upper branch was a petition road was false. Then the court changed its mind and said, well, your prescriptive easement claim will succeed. It hasn't been extinguished by reverse prescription. I would submit I can stand in the middle of the county courthouse. I can tell everybody, don't come on my road, it's a private road. And as long as I keep them off the road, I can extinguish the easement by reverse prescription.
Mr. King, how do you address the court's conclusion that Letica couldn't raise that argument because the gates weren't on Letica's property? It didn't place the gates, and so it couldn't claim reverse adverse possession.
Your Honor, there were gates on our property. The green gate was on our property. And I would submit to you, if you look at Letica 11, the gate at the intersection of Spring Gulch Road and this lower branch wasn't on the county road as it was shown on the petition.
Right, but the district court says that Letica's argument is that someone else blocked the road on Letica's land, and that position had been specifically rejected by this court in Boone and Crockett, that you can't rely on someone else's actions to claim reverse adverse possession.
Yeah, but my client showed up and the road was already blocked and had been blocked for 9 years. And it stayed this block for another 23 years. So I'm not sure if we were expected to add more gates to the ones that were already closed and locked. It had been locked for 9 years and it remained locked for another 23 years. This case is not supported by the law. And I would submit that if this is the law of road law and easement law in the state of Montana, we've got some problems. I respectfully request that you reverse and allow my clients to proceed on their constitutional claims, which were summarily dismissed. Thank you.
Thank you, Mr. King. Thank you to all counsel. This matter will be taken under advisement and we'll issue an opinion in due course.